Hello friends, in the series on the income tax cases, today we will discuss a unique case. The title of the case is CHAUDHURI versus Assistant Commissioner of Income Tax and others. This case has been reported in 455 ITR at page number 284. The matter has been decided by Calcutta High Court and the date of the judgment is 18th January 2023. The purpose of discussing this case is that if the assessee missed some claim which he has to make in his return of income and the time expires for filing the revised return, so the question arises whether the assessee can take the recourse of section 264, that is for revision of other orders. In 263 the department goes for the revision and in 264 the assessee goes for the revision. When the assessee opts for 264, then the assessee loses its right to challenge this order, the order of the Commissioner of Income Tax in the higher forums like the ITAT. In this case, the assessee filed his return of income for 2 years in which the assessee taxed two incomes which were exempt. One income was dividend income and the other income was the sale of shares of unlisted companies, the sale of shares of listed companies. When the assessee received the order under section 143 subsection 1, the assessee realized that the assessee should not have paid the tax on these two incomes, but the assessee do not have the time to file the revised return because the limitation for filing the revised return has expired. The assessee chooses to file revision under section 264 before the Commissioner of Income Tax, but the Commissioner of Income Tax rejected the application of revision of the assessee under section 264 on the pretext that there was no mistake or the order under section 143 subsection was not erroneous, so the assessee cannot take the recourse of revision under section 264. The assessee filed the writ against the order of the Commissioner of Income Tax, and when this matter came before the Calcutta High Court, the Calcutta High Court was of the view that the Commissioner of Income Tax has misinterpreted the judgment of the Honorable Supreme Court in the case of Assessee India Limited. The Assessee India Limited case says that if the assessee has to make a fresh claim, then the assessee has two options. He can file his revised return, and if the time for filing the revised return has expired, then the assessee can claim the additional claim which he has not claimed in the original return at the appellate authorities like CIT appeal or the ITAT. But the Commissioner of Income Tax in this case said that the Assessee India Limited will apply here, and even the Commissioner of Income Tax cannot give the relief to the assessee when the assessee has not filed the revised return. The point was that the High Court said that the Commissioner of Income Tax has misinterpreted the judgment of Assessee India Limited by assuming the jurisdiction of the assessing officer as the same of the Commissioner of Income Tax. The court said that the jurisdiction of assessing officer is different and the jurisdiction of Commissioner of Income Tax is different. In this case, the High Court was of the opinion that the Commissioner of Income Tax should have considered the application of revision of the assessee under section 264 and has not equated his jurisdiction with the assessing officer in line with the decision of the Supreme Court in Assessee India Limited. So the crux of the theory is that the court said that in this case the jurisdiction of assessing officer and CIT is different, and if the assessee has missed some claim in its return and even if the time period for filing the revised return has expired, then the assessee can opt for section 264 and the CIT should have considered the application of the assessee for giving the claim to the assessee, or at least consider the application of the assessee on merits. By the judgment of this case, I reminded one case of the Supreme Court in the case of Urban Development Trust. In that case, the Supreme Court has said that the officers of the income tax department are reluctant to take the decisions, due to which the burden on the courts increases, and it is generally seen that the burden of the fiscal authorities is shifted to the various courts, including high courts and supreme courts, because of the incompetency of the officers of the department not to take the or to take the decisions. They shift the burden, they shift their burden to the judicial forum. So this approach should not be adopted. If any issue comes before them, then in spite of rejecting the applications in limine, they should consider it on merit. At the end of this case, once again I am repeating the name of the case. The name of the case is CHAUDHURI versus Assistant Commissioner of Income Tax and others, and this case has been reported in 455 ITR at page number 284. The date of the judgment is 18th January 2023 and the matter has been decided by Calcutta High Court in a writ petition filed by the assessee.